What is an heirship affidavit? An affidavit of heirship identifies the heirs of an estate to real property. It is signed by two disinterested witnesses who state to their best knowledge the marital status, children, and family of a decedent. Now, notice here I'm highlighting some things in red, okay? The reason I'm highlighting these things in red is because they're very important distinctions I want you to make. First off, we will go over later what disinterested witnesses are. And under Texas law, Texas Estate Code Chapter 203.001 lays out a path to establish prima facie evidence for an estate's heirs without a court proceeding. Those are some big words, but let's go through what that actually means and what's actually happening. Prima facie means evidence sufficient to establish a fact or raise a presumption unless disproved or rebutted. In a court of law, it's very difficult to establish facts. Most things that we deal with are people's opinions. It's hard to really know what actually happened at a circumstance. And an heirship affidavit is designed to eventually establish a fact. Now, it takes time. It takes 5 years after an heirship affidavit has been filed and the processes that we're going to talk about later are followed correctly. It will establish it as a fact. Now, just because it's prima facie evidence for a fact, it doesn't mean that it can be overturned. Who can be a disinterested witness? Who actually can sign the document in order for us to file it and it be effective? We're supposed to have two disinterested witnesses. Most title companies want one family member and two disinterested witnesses. They want a bunch of people to identify because they're the ones insuring this property and they're the ones that are taking the risk. An individual who can state the following can be a disinterested witness. The decedent did not owe any debts. It's very important. If they owe debts, you have to go through a probate proceeding to make sure, or pay off those debts. You got to pay off the debts first before you do the affidavit of heirship, or you need to go to court in order to handle the debts of an estate. The identity of the family member and the heirs of the decedent. So we want to know, hey, who is really supposed to inherit this property? That the decedent died on a certain date and in a certain place. A witness, this is the most important, key one. The witness will not gain financially from the estate. Now this becomes a difficult question. If you're the spouse of an individual who's going to inherit, so you're a child, your husband is a child and is going to inherit, are you financially gaining from that? It's always the best practice to find people who are completely independent, who will receive no gain at all. However, a lot of times we have no choice and we have to go with who's available. So disinterested witness should have no financial gain. Considerations. What considerations should you take into effect when you're actually putting this together? First off, this is getting a little complex. A lot of people think that, oh, these are simple. You just go get a form offline. Probably not the best idea in a complicated situation that you're dealing with multiple heirs. Yes, a lot of times the forms online will work, but here are some things to think about. Property description of the real property. You need to know what it is and put it in the actual document correctly. A statement that the decedent passed with or without a will. If a decedent had a will, all the beneficiaries in a will and the heirs under intestacy must sign a family settlement agreement to the ownership of the real property. This is a very important step, a very important thing to understand. A lot of people think, well, I have a will, therefore it's valid when I die and that's where my property is going to go. Wrong. That's not how it works. You have a will. That will still needs to be proved in court. It needs to be established as your last will and testament. But if you pay attention to what we're doing here, we're not going to a court. We're bypassing a court. We're going outside. So, since the will has not been filed and not been proved, intestacy law is what would distribute the property. So we have two different laws here. We have the will, and then we have intestacy law that's distributing the property. So if we want to do the affidavit of heirship route, we need to have all those parties come together, write up an agreement together on how the property is to be distributed, and file that the affidavit of heirship. We want to attach that will to it and the family settlement agreement all together to show how the property is going to be distributed, and then you would not have to go forward and probate a will. Now that gets real tricky. You have to read the will very carefully, make sure you understand. You have to understand intestacy law and how the property is being distributed under intestacy law, which most people, even attorneys, struggle to understand. List all the heirs' names and addresses. We want to be able to contact them. List all other parties and interests to the property. For example, a life estate holder. So if someone has a life estate interest, they don't have a beneficial interest, they have a life estate interest, they need to be included. The marital status and history of the decedent. A common mistake is not identifying if an individual was actually legally divorced. In Texas, bigamy is illegal, and all second marriages are legally null and void. This has actually happened a few times in my practice. We have a spouse who's trying to get a piece of property. They don't have a will. They want to do an affidavit of heirship. So they come to my office, and I'm happy to help them. As we start going through this process and doing everything, we come to find out, lo and behold, so-and-so was married 30 years ago, and we have no record of divorce. That's a problem. We have to find some record of divorce, some testimony from someone saying, yes, I saw them. They went to a court. They were legally divorced. I understand records from the past sometimes are pretty shaky, and it's hard to find them. So we need to identify. That's a consideration that has happened a couple times in my office. So make sure that that step is not skipped. All right, warning. Do not sign an affidavit of heirship you know is incorrect. This can result in a $10,000 penalty plus damages to the individual harmed. I've had a few people tell me as we were going through things, well, that's incorrect. And I'm like, well, why'd you sign it? Oh, well, you told me to sign it, so I just signed it. Well, don't do that. Don't sign something that's incorrect and you know is incorrect. Send it back to the attorney and say, that's incorrect. Can you have that fixed? The two-step process. There's a two-step process to doing this correctly. First, affidavit of heirships by themselves do not cure title defects. An individual with first-hand knowledge of the family history must file a signed affidavit of heirship, and after the affidavit of heirship is filed, all heirs must sign a deed conveying the real property of buyers. Okay? Common mistakes. An escrow officer. So escrow officers at title companies usually are handling this process. So often escrow officers in a hurry to close will draft a deed and find out that they need to do an heirship affidavit. They have the deed signed and executed and then go create an heirship affidavit. Texas Estate Code 203.001 lays out the process. The affidavit of heirship must first be completed and filed, and then the deed be created. The deed is usually a special warranty deed or deed without warranties. Do not execute a quitclaim deed. This can cause an issue with many title companies. For some reason, attorneys love quitclaim deeds. They just cause problems. Either give a deed with no warranties or a special warranty deed. That's how you should transfer the property when you're creating this. Now, the other very important thing is all heirs named in the affidavit or their legal guardians must sign a deed. You can't have one person transfer, which usually becomes an issue when you're going through a probate and one person doesn't want to transfer anything. So, let's say that happens. You go through everything and one of the heirs refuses to sell the property. They're living in it. They don't want to sell it. Well, in that situation, you can force the sale, but you gotta go through a court. This process is if you want to avoid the court process, giving you all the rules that you need to follow. Drafting them can be kind of difficult. It's going to require understanding things. If it gets a little complex, you absolutely need to have an attorney draft this document to make sure it's done correctly so the people who are signing it don't get in trouble.